With Donald Trump expected to be in court tomorrow to face 37 federal charges, it's time for some straight talk and analysis about the charges and the defenses we've been hearing this weekend. Because a lot of what is being spewed in the partisan media is either misleading or just downright untrue. Look, this case has the potential to divide the country even further. And regardless of what you think about whether charges should have been brought at all, and we will have a serious discussion about that in a bit, we need to move forward with one set of facts. After we learned the former president had been indicted, but before we saw the actual document, I said I'd wait for the details before passing judgment on the strength of the case. I also said it would come down to how much evidence the special counsel had of intentional conduct, that Trump knew he had classified government documents and that he personally took specific actions to hide them in response to a federal subpoena, that he did it on purpose. And I actually went a step further. I also said that it should matter how sensitive the documents were. Even if legally they were classified and you could charge for that conduct. I've long believed if you're going to charge the former president of the United States, who is now a candidate, the leading candidate, for the Republican nomination, the standard should be higher, must be higher. The consequences are too grave. And so the documents also needed to be more than just a letter to Kim Jong-un or something that was just technically classified. Well, now that the 49-page indictment is out, any fair reading of the allegations would lead to the conclusion that this is almost a legal worst-case scenario for Mr. Trump. I care much less about the photos of documents in places they shouldn't have been, like ballrooms and bathrooms, and much more about the audio tape of him sharing highly classified plans for a potential military strike on Iran and admitting that he could no longer declassify it. And the witnesses from inside Mr. Trump's orbit reluctantly testifying that he instructed them to hide the documents and lie. And maybe most importantly, the documents themselves appear to have been the most sensitive types. From U.S. nuclear programs to defense and weapons capabilities of the U.S. and foreign governments, and even potential vulnerabilities to military attack for the U.S. and its allies. And while there's a legitimate big picture debate to have over whether, even in spite of the evidence, this is all worth pursuing, as a legal matter, it's not surprising that even the more pro-Trump legal analysts agree that the actual charges will present significant challenges for Mr. Trump in how to defend himself in court.
It is an extremely damning indictment. There are some indictments that are just bare bones. This is not. These are witnesses who apparently testified under oath, gave statements to federal investigators, both of which can be criminally charged if they're false. Those witnesses are directly quoting the president in encouraging others not to look for documents or allegedly to conceal them. It's damaging.
It does seem that they are saying that these 31, at least, they think that they can prove that these are national defense.
Yeah. The one page that's of concern, obviously, if it's true, is the tape recording that was made of a conversation ex-President Trump had with a writer. This is the one that should be worrisome to the president. He may have an answer for it.
If even half of it is true, then he's toast. I mean, it's a very detailed indictment, and it's very, very damning.
But what we're seeing from many political allies of the former president and from Mr. Trump himself is not a nuanced argument about the dangers of bringing this type of case. Instead, it's often a combination of long-shot legal defenses mixed in with more political ones alleging bias and selective prosecution. So it's important to address these before having a real discussion about whether, despite all the evidence against him, charges should have been brought. So let's tackle the four big ones. 1, if this is a crime, why wasn't Hillary Clinton charged? 2, did Trump have the right to declassify everything anyway? 3, does the Presidential Records Act give the president the authority to determine which documents are his and which should belong to the government? And 4, what about the classified documents that Joe Biden had? Let's start with number 1.
What I don't like is a system in America where the Secretary of State, who's a Democratic candidate for president, has people take a hammer to social media devices and break them apart, apply bleach bit to a hard drive to erase emails. Most Republicans believe we live in a country where Hillary Clinton did very similar things and nothing happened to her.
You have a former First Lady, Senator, Secretary of State that had the same situation that nothing was done to her.
When caught, Hillary deleted and acid washed 33,000 emails in defiance of a congressional subpoena. She already had the subpoena. And her aides smashed and destroyed iPhones with a hammer. Yet the FBI and DOJ protected her.
In the Trump case, according to special counsel, Mr. Trump was intentionally trying to hide very sensitive documents from the FBI after he received a subpoena. Prosecutors in the Clinton case, on the other hand, determined that the evidence and facts showed a, quote, lack of intent to communicate classified information on unclassified systems, especially since, quote, none of the emails Clinton received were properly marked to inform her of the classified status of the information. And according to a report from the DOJ Inspector General, who actually investigated the decision not to charge after the fact, said prosecutors concluded there was no evidence that the senders or former Secretary Clinton believed or were aware at the time the emails contained classified information. Now, whether they were right or wrong, and I think it was very wrong, of course, to have that server, but wrong doesn't necessarily mean criminal. Prosecutors did not believe that they could prove intent. That's critical. Okay. But what about the more than 30,000 emails, which her legal team deemed personal and deleted from the server at her home? In retrospect, it was a mistake to delete what they did. But the Inspector General concluded there was no evidence that Clinton or anyone else intended to conceal, remove, or destroy the emails from government systems. As for the claim of acid washing, it's actually just an inaccurate reference to an open source software program that happens to be called BleachBit. Now, if you go through every piece of evidence, as the prosecutors and the Inspector General did, from the phone that was destroyed to the emails, they didn't believe there was evidence of corrupt intent. And that is what the law requires. And to those who say, come on, Comey and the FBI clearly had it out for Trump and not for Hillary Clinton. They protected her, just as the former president said. The problem with that, of course, is that James Comey announced 11 days before the election that they were reopening the Clinton investigation, even though it turned out there was nothing new. And most importantly, the FBI never leaked that there was an ongoing Russia investigation of Donald Trump, which would have significantly hurt his campaign. If the FBI wanted to help Clinton and hurt Trump, you don't announce the reopening of the Clinton investigation right before the election, and you do announce that the Trump campaign is being investigated for its contacts with the Russians. Except that's not what happened. All right, topic two.
And when he was president, he declassified the material.
He says point blank. He says point,
when he was
which
president,
means that
he
it's
did declassify.
classified.
He said that.
I did declassify, yes.
Okay. Is there a process? What was your process to declassify?
There doesn't have to be a process, as I understand it. You know, there's different people say different things, but as I understand, there doesn't have to be. If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it.
It's true that as president, Trump could have declassified everything. And even though the argument that he actually did is a very weak one, it's irrelevant in the context of this case for two reasons. First, the subpoena from May of 2022 requested all documents with classified markings, not all documents currently classified. So whether it was still classified isn't the point. But more importantly, none of the charges, none of them, allege illegal retention of classified documents. He's charged for obstructing the investigation, hiding and lying about the documents after the subpoena was issued. And the 31 charges for withholding highly sensitive defense information under the Espionage Act do not hinge on whether any of it is classified, just on whether it's, quote, unlawful retention of defense-related information. And it seems there's no doubt it was defense-related and it was retained. But that brings us to number three, which is whether the retention of even these sensitive documents was illegal at all.
As president, all of my documents fell under what is known as the Presidential Records Act, which is not at all a criminal act. Everything. It's all judged by the Presidential Records Act. In this whole fake indictment, they don't even once mention the Presidential Records Act.
But the reason they didn't mention the act is because it's almost certainly not relevant to the case. The argument Trump is making is related to 79 audio tapes that Bill Clinton made at the end of his presidency in preparation for a book and a lawsuit from a conservative group that alleged those tapes should be considered presidential records, and the National Archives, and not Clinton, should be able to keep them. So in 2012, federal judge Amy Berman ruled that in effect the case was moot because, quote, and the language is important, the Presidential Records Act does not confer any mandatory or even discretional authority on the archivist, basically saying it's not really up to the archivist. Under the statute, she wrote, this responsibility is left solely to the president. Solely to the president. Well, that language, Trump's team will argue, means that it's his decision, not that of the National Archives, on what should be considered presidential records. But there are a number of major problems with that. First, the Bill Clinton tapes were like a personal journal he made for himself. Trump took highly sensitive government documents, and the courts have made clear that agency records, which many of these were, are not covered by the Presidential Records Act. Think about it. Using the Trump team's logic, the former president could take any and every government document, no matter how sensitive, and just claim it's his. Now, of course, that can't be the standard. But even if you think it could apply, it's almost certainly not relevant here for the charges of obstructing the investigation, nor to the 31 counts for the willful retention of national defense documents. Those charges are not about a dispute between the National Archives and the president over who should keep the documents, as was the case in the Clinton matter. This is a charge that the nation's security was put at risk by the retention of the documents, period. Finally, argument number 4.
But I hear how wonderful he did. Think of it, 1,850 boxes he had. Mine is peanuts. But you saw mine because they were on that sidewalk.
First off, let's be clear. There is a special counsel investigating Biden, Robert Hur, a registered Republican and a Trump-nominated former U.S. attorney. We will see what happens. We know former Vice President Pence will not be charged. Yes, Biden's personal lawyers found 10 classified documents, some marked top secret, in a box of other material in a storage closet at the University of Pennsylvania's Biden Center. And a small number of classified documents were also found inside his garage at his Delaware home. We don't know how sensitive those were. But there is no evidence at this point that he lied or intentionally tried to hide them. In fact, President Trump initially handed over 15 boxes to the National Archives, including over 180 classified documents, including 92 marked as secret and 25 as top secret. And then in response to the federal subpoena, he turned over 38 more classified documents. Look, if he'd handed them all over even then, even after initially hiding them from the National Archives, there would be no charges, period. As for the 1,800 or 1,850 documents we keep hearing about, those are a collection of donated documents from Biden's 3-decade tenure as a U.S. Senator from Delaware. Unlike presidents who are subject to the Presidential Records Act, senators own their office's documents. They can keep them at their homes. They can donate them. They can give them to the media, whatever. But here's where that argument falls really flat. Biden consented to 2 FBI searches at the university, searches that did not initially appear to turn up any documents with classified markings. I've said it before. Look, I think this indictment is bad for the country. It will, and it is, further dividing us. But that doesn't necessarily mean you can't bring charges. Look, I thought the New York case was weak and politicized, and I said it. This is different. This is based on the evidence. Even if it is bad for the country, there's nothing to indicate it's politicized. Remember, this is the same DOJ that defended Trump over the objection of many on the left more than once. Remember, first, In one of the cases E. Jean Carroll brought for defamation and sex assault against Trump, they argued that Trump made the comments in his role as president, and A.G. Garland had to explain himself to congressional Democrats. And last month, the DOJ stepped in again, controversially and over the objection of many on the left, to prevent former President Trump from having to testify, at least for now, in connection with a pair of lawsuits filed by former FBI officials Peter Strzok and Lisa Page, the FBI agents who sued after being removed from the Mueller investigation. The DOJ won on behalf of Donald Trump. They did not have to take those cases. So there is nothing to indicate this decision from the special counsel was politicized. But even despite all of that, it still leaves us with the big picture question of whether he should have been charged at all. And on that, I'm not as certain. It's hard to argue with all this evidence that you don't move forward with the case. But there is a legitimate argument that the impact on the country is so severe. My next guest wrote a piece for the Washington Post making that case. We'll discuss and debate after the break. Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.